Sure, why not? Okay, so welcome to the chapter's first virtual education event. Obviously, this is probably what our education events will look like for the foreseeable future. So we're doing our best to adapt to the new normal, just like you all are. I hope everybody's staying safe and healthy. My name is Nick Berg. I'm your CAI BayCen chapter president. We have some additional board members in this Zoom meeting: Edith Murphy, Sarah Brown, Laura Ravazza, and our executive director, Kelvin Nanny. The San Francisco subcommittee chair is here today. A special thank you to Sarah Brown of the Miller Law Firm. Our sponsors, before I announce them, I really want to say how grateful I am to our sponsors for supporting the chapter through this crazy period. I never imagined we'd be going through anything like this, and they've really stood by us. So I really strongly encourage all of you to give preference to our sponsors as things are lifted and you're looking for work. Today's program sponsors are Cagwin and Doward, Chex Law, Empire Works Reconstruction and Painting, Heritage Bank of Commerce, Hughes Gill Cochran Tinetti, Levy Erlinger and Company, Newman Certified Public Accountants, Sarman Construction, Sachs Insurance Agency, and Signature Painting and Construction. Today's registration table sponsors are AC Enterprises, Alliance Association Bank, Fenton Grant Law Firm, the Miller Law Firm, Socher Insurance Agency. Thank you again to our sustaining sponsors. Please enjoy the new 2020 sponsor video.
Oh, we're going to show you the sponsor video for the San Francisco sponsors first.
Okay.
Let me
roll it.
Hi everyone, Heather here with Empire Works Reconstruction and Painting, serving your HOA communities over the last 15 years. I hope everyone is staying safe and healthy, and I can't wait to see everyone in person again.
Hello, my name is Demetrios Exanthos, and I'm the principal of Sachs Insurance Agency.
And I'm Mimi Cortez, Marketing Director for Sachs Insurance.
I would like to personally recognize and congratulate property managers, board members, and service providers who are on the front lines servicing our associations during this COVID-19 pandemic.
Our company has successfully transitioned to a home office environment, and we continue to put our clients' needs first.
I know we can win.
Don't forget to practice social distancing, and don't forget to wear your mask.
The Miller Law Firm, assisting homeowners associations in their construction defect needs for 40 years. Levi Erlinger and Company, CPAs. Adam Sterling. AMS Incorporated. Black Diamond Paving and Concrete. Black Diamond Roofing Incorporated. GB Group Contractors Consultants. IQV, Construction and Roofing. JPA, Landscape and Construction. Kasdan Lipsmith Weber Turner. New Pipes, Incorporated. Roof Works and Construction. Sarman Construction. Witt's Painting. Varsity Painting. AC Enterprises. Birding Weil. Chapman and Interior. CM Squared.
For over 18 years and 10,000 satisfied associations, Empire Works can handle any size painting and reconstruction project that you may have. We look forward to doing business with you in 2020.
Benton Grant. Heritage Bank of Commerce. Hughes Gill Cochran and Janetti. The Miller Law Firm.
We are Recon 360. We are general contractors specializing in reconstruction, roofing, painting, and maintenance services. Recon 360 gets projects built to code, built on time, and built to budget.
Signature Painting and Construction.
Social Insurance here to show you our stuff. Okay, maybe let's stick to do what we do best, HOA insurance. It's all we do and all we've done for the past 30 years.
Dark Construction.
Back to you, Nick.
Okay. Please follow us on social media. The chapter can be found on Facebook, LinkedIn, and Instagram. Please keep your video off, but more importantly, keep your microphones muted. If you're looking for the mute, it's on the bottom left side of your Zoom screen. Questions may be submitted using the chat feature. Questions will be answered at the end of the presentation. We have a few upcoming virtual programs. The CID Law course, which is directed towards board members, is on May 4th, 6th, and 8th. It's in 3 2.5-hour sessions. If you have any board members that you would like to give them board training, that is a great one to get them on. We also have a South Bay Virtual Education Forum on Friday, May 15th, and the Stockton Educational Forum on Tuesday, May 19th. Now I would like to invite Sarah Brown to introduce our speakers. Sarah?
Thanks, Nick. And thanks to everyone who is joining us today. Please make sure to complete the Zoom poll before exiting the meeting to let us know what you think of the chapter's first virtual education event. We also welcome you to submit your questions through the chat feature, and Charlotte Allen with Social Insurance Agency will moderate the question and answer segment directly following today's presentation. Now it's my pleasure to introduce today's speakers. Stuck Inside, Addressing Secondhand Smoke Issues During a Shelter-in-Place Order is being presented by Alex Noland of Noland Law PC and Robin Romo of CitiScape Property Management Group. Enjoy the program.
Okay, everyone. So I think you should see our program on your screen now. Robin, do you see it?
I do.
All right, perfect, perfect. Thanks for the introduction, Sarah, and thank you for everyone that came out today. So today we're going to be talking about secondhand smoke issues. Robin and I are going to go over some national trends, some basic information, but then also kind of dial down and talk specifically about things that associations need to be worried about, things that associations can do, things relating to smoking restrictions and things like that. And so we're going to kind of do an interactive back and forth thing. I'll do a couple slides, Robin will do a couple slides, maybe we'll interrupt each other, who knows, but it'll be a good program. And for those of you wondering, it's not a virtual background behind me. This is actually wallpaper in my dining room wall. So very exciting. So, okay, so introduction. So I think is pretty much everyone on the, in the meeting has heard before. Secondhand smoke has been categorized as toxic, carcinogenic, cancer causing. So there's a lot of health concerns related to it. But also there's things like odor issues, fire that could start from smoking, litter issues relating to cigarette butts and things like that that associations need to be worried about. And then when we're talking about secondhand smoke, and we'll get into this in more detail later, smoke can really travel in a lot of different ways. It's kind of like water that way. We don't always know how smoke is going from one unit or one part of a property to another, and it can go through ventilation systems, cracks in walls, floorboards, light sockets, things like that. So we'll talk a little bit about trying to trace smoke and what some of the issues with that are. And then, you know, aside from the health issues and litter issues and everything else, secondhand smoke's a nuisance issue. I deal with this, it seems like almost on a weekly basis with managers and board members, complaints about secondhand smoke. Sometimes we know where it's coming from, sometimes we don't know where it's coming from. And we'll talk about how to deal with these sort of complaints and look into them. Following up on our introduction, you know, the trend I think a lot of people probably already know is that smoking is going away. It's being banned, it's being restricted in a lot of cities and counties and different areas. I think that, you know, the number of people that smoke in America is less than half of what it was 30 or 40 years ago. And so we've really seen this trend, especially in multi-unit housing like apartments, condos, stock co-ops, things like that, where smoking is being prohibited on a local basis. And it's not going to surprise me at some point if the state of California or other states actually do statewide bans on smoking in attached housing. And when we're dealing with smoking issue, you know, I think that a lot of people think my home is my castle. I live in a condo building, but I should be able to do whatever I want in my, my home. And so when we're telling people you can't smoke, either because the city says you can't, or because the association CCNRs prohibit it, this can really bring up emotional issues for people. You know, freedom of, I want to smoke, but also if you smoked forever, people don't want to be told they have to change their behavior and stop doing what they've been doing. So on a national level, as I said, the trend has been to limit and restrict smoking in a lot of different cities and counties and areas, especially within multi-unit housing. There have been cases all over the country about smoking issues and smoking nuisances. Courts have held that secondhand smoke can be a nuisance when it's offensive to people of ordinary sensibilities, even if there's no specific health injury or property damage that accompanies that. But the thing we need to keep in mind is that, as with every nuisance issue that we're dealing with as board members, managers, attorneys, business partners, that hypersensitivities aren't necessarily the thing that we're catering towards, right? So what would the average ordinary person think about the issue, whether it's smoke or noise or light or vibration or whatever it is? And so boards need to think about, would an average ordinary person find this smoke issue to be a problem, or is it not really something that we can find out what's going on, or we don't consider it to be problematic? And then this kind of final note here, some courts have held that 6 cigarettes a day can constitute a violation or does not constitute a violation, where other courts have said 60 cigarettes a day does, which is a lot. And so Robin, I'm going to turn this over to you.
Great. All right, so let's talk about California smoking laws. Under the California Business and Profession Codes, what is the actual definition of smoking? So as you can see, it's the inhaling, exhaling, burning, carrying of anything that's lighted, heated, cigarette, cigar, pipe, whether any product really that is intended for inhalation, right? Whether it's natural or synthetic, no matter what form it is considered smoking. So important for all managers to be aware of that. The other thing is that, you know, as we know, everything has kind of changed in terms of the smoking field. So it also now includes the use of any electronic smoking device, right? So whether if it creates a vapor or an aerosol, no matter what form it is, if it's meant for oral smoking and it's meant to kind of circumvent the whole, you know, smoking law, the prohibition of smoking, that is still considered a definition of smoking. So important to keep that in mind. And now this is really funny to me because I remember when this happened, I was at my first job. California is referred to as America's non-smoking section because we were the first people, or the first state in the country to ban smoking in almost every single workplace and in all indoor public spaces. I remember at my first job at our lunchroom, we actually had a smoking and a non-smoking area. And so that changed with AB 13 in 1995. So it's funny, everyone always talks, the rest of the nation talks about how California is so different from the rest of the union. Well, we are. Our law is one of the most restrictive in the nation, and there are very few exemptions to those laws. So where is smoking prohibited and in what areas? So basically any enclosed space of employment, or even if it's an owner-operated business, so that would include parking lots, lobbies, waiting areas, elevators, anywhere where people maybe in the past have been able to smoke, anything that's enclosed is no longer allowed. Now, this is really important for all of us community managers, would be indoor common areas of apartment and condominium complexes. So hallways, stairwells, laundry rooms if you have them, amenity rooms, if these places are areas of employment, right? So public housing units, states, county, city buildings, so we're talking local, state, federal, or excuse me, local, county, certified public markets, anywhere there's kids, tot lots, playgrounds. What came new as of January 1st of 2020 would be parks and beaches. Not that I don't think any of us manage parks or beaches, but if you do, it is now not allowed. So again, additional places where this is not, where smoking is not allowed, you'll see the list on there. What was surprising for me is actually the motor vehicle. If you have a minor present in a motor vehicle, whether or not the vehicle is in motion, it is not permitted.
Great. All right, so now we've talked a little bit about statewide laws. So now we're going to focus on what's going on in the San Francisco Bay Area and Central California. So you can see there are a lot of cities and counties that have full stop banned smoking in attached housing. So whether we're talking about townhomes with shared walls, condominium high rises, stock cooperatives, apartment buildings, things like that, the list here at the top are cities and counties where you cannot smoke in attached housing. It's a lot of different places. And again, this is just Bay Area and Central California. If we threw in Southern California, Central Coast, other areas, the list is much, much bigger. And then there's a few areas up here that have approved smoking bans in multi-unit housing that haven't gone into effect yet. So Benicia, Healdsburg, Pacific Grove, Pacifica, San Carlos, and San Pablo. And all of this information is effective as of April 1st. So maybe in the past 3 or 4 weeks, there have been some more that may have been added to this. So we can see really the trend is, especially here in California and Northern California, we're banning smoking in attached housing. We're concerned about the health effects and the nuisance issues. So now we're going to get into more of a generalized discussion about secondhand smoke issues for associations. And so, as an initial kind of thing that we need to think about is this affects different associations different ways. So if we're talking about a condominium building where you're in a high rise or mid rise, you've got units, you've got hallways, no one has their own front door, everything's attached, the smoking issues and concerns are going to be there than if we're in a planned development out of Modesto where everyone's got their own yard, nothing is attached, things like that. So really the smoking issues are going to vary based on the type of HOA and development that you're living in. And then the other thing we need to think about when you have a board that says, I would like to ban smoking in the common area or in units, or I don't want to ban smoking in the units or the common area, we really need to look at, are there any city or county laws that currently regulate this? Because if a city or county says that you can't smoke in your units, then you can't smoke in your units, right? So I think it's each association being aware of what is its local city and county laws with regard to that. Now, let's say that you had a city or county that said, you can't smoke in the common area, but it doesn't regulate units. A board could, of course, go and try to adopt a governing document amendment that bans smoking in units, and we'll talk about that. But the restriction you put in can't be less restricted than whatever the city or county standard is. And then if there is no city or county standard, so here in San Francisco, we don't have one with regard to residential buildings. There's a law that you can't smoke within so many feet of windows, doors, and ventilation shafts of buildings where you have housing, but there's no ban on smoking in attached units, is that you really need to think about, if you don't have a city or county ban, how are you going to deal with this? And that's where we start looking at the association's governing documents and determining what are the provisions in the CC&Rs and the bylaws about adopting rules, about regulating use within units, things like that. So Robin, back to you.
Okay, so what are some of the criteria used for association smoking restrictions? Well, I think first, it's important to understand what the general goals are, right? So we already know that there are nuisance issues. I can't imagine there's any manager here who's never had to deal with a neighbor-to-neighbor complaint, smoke traveling, fire risk. That's a big deal. I actually had a person in one of my associations who fell asleep with a cigarette in their hand and set themselves on fire. Their unit caught on fire, they caught on fire. It was a bad issue. And then of course the litter issue, because if you're on a lower unit, you're probably going to get someone throwing their cigarette butts down on you. So yeah, those are kind of the general goals of smoking restrictions. But that being said, anytime you put into a smoking restriction or a ban, you want to be really careful about giving the impression to residents or homeowners that the HOA is trying to provide for their health and safety, right? That's not what the HOA is responsible for. So we just have to be careful in how that's presented to the residents. Now, as you know, most associations can ban smoking in the common area. Again, depending on where you are, what city, what county. Now, some associations, although it's a little unusual, may want to actually establish an outdoor smoking area. And if they do, again, there are some restrictions. So there has to be a suitable location for it. You have to adopt protocols regarding the use and the maintenance of said area. And again, depending on what city and county you're in, smoking in the common areas may not be allowed at all, right? So, you have to make sure that it is not prohibited in your area. So that's really important. Now, an association may also allow owners within certain individual buildings, if you have, depending on if you have several buildings within that community, they can allow individual owners to decide for themselves whether they want to declare their buildings as smoke-free, if it's not already banned.
Right, and that last point, so getting back to what you said, Robin, this whole idea of allowing smoking areas in the common area, I'm not a fan of this, right? It should never be inside. But as far as outside goes, I just think there's too much risk. I do have some communities I work with, like bigger planned developments where it's single family home, where maybe they do want to allow that. But as a general proposition, I'm concerned about it. And if you have an association that says, well, we do want to have a smoking area by the pool or the outside, wherever, you probably should talk to your insurance agent or broker, because there could be some sort of liability issue or claim exclusion if you have a pollution claim or injury or fire or something like that. Now, with regard to this last point that Robin brought up, it's kind of interesting here. So you and I talked about the fact there's a development down in Orange County that I worked with for a number of years. It's a big age-restricted stock co-op, and they had multiple buildings, dozens of buildings. I think they had over 6,000 different units in the development. And it was, because it was age-restricted, a lot of people that had grown up smoking that were smokers, but as newer people were moving in and the trend about non-smoking happened, there was a real discussion with the board of directors of this co-op and the residents whether they wanted to allow smoking or not. And so to try and go and get the bylaws or the occupancy agreement or their operating rules amended to ban smoking development-wide was going to be an issue, but this board kind of did a thoughtful analysis of the issue, and what they did was they came up with some rules and a policy that would allow all the individual owners of every unit within a building to go through a process to basically unanimously agree to declare their building smoke-free, and then there were some things that were recorded and done to document that. Very unusual. That's the only time I've ever dealt with something like that before. But if you're managing or you're governing a development with a lot of different buildings, this may be a creative solution to look at if it's going to be a problem to go and get a CC&R amendment or a governing document amendment that you think you can't get a majority of the owners to approve. So I hope you'll like the picture of the cat. So with regard to smoking restrictions, is that, really, if there's no city or county ban, you can only prohibit smoking in units or residences if you have it in your governing documents, right? And so then the question gets to be, what governing document? So as a general proposition, as I'm assuming everyone on this call or in this meeting knows, is that when you're adopting operating rules, they fill in the holes, right? They don't contradict, they don't change what's in your CC&Rs, your underlying documents. So for example, if you've got a swimming pool in your development, then you could have pool rules that say, here's the hours, no more than 3 guests, no alcohol, no glass, no nudity, things like that. It's kind of the same concept when we're dealing with nuisance issues like smoke, is that if we're trying to regulate what people are doing in their unit, there typically needs to be some sort of CC&R provision that would prohibit that. I really question the fact whether an association could adopt a rule, a board could adopt a rule that says no smoking in units to the end, absent anything else in the CC&Rs. So this is going to be probably a document by document type of situation. So you want to talk with your association's attorney about this, but you're typically going to want a CC&R amendment because that's the most enforceable thing. And the trend I've seen recently is with brand new buildings here in San Francisco, the original developer drafted documents are actually banning smoking from the get-go where it's not allowed in the building. And so I think we're going to be seeing more and more of that, especially with our newer developments. And then the second point here, and I think Nick Berg and I were actually talking about this the other day, is that just because an association's board of directors can adopt a rule doesn't mean it should. And whether we're talking about smoking or nuisance issues or play activities or common area recreational use or whatever it is, because once you adopt the rule, you have to enforce the rule. And if the board doesn't, it's breaching its fiduciary duty. So if you have a board that wants to ban smoking in the common area or pursue a CC&R amendment to ban smoking in units, assuming that that gets approved or adopted, now the board has to enforce it. And the person that doesn't like smoke, or the person that doesn't like the board and is always watching everything they do, the minute there's a scent or whiff of someone smoking in their unit, they're going to be all over the association to take care of the issue. So I'm not suggesting that boards shouldn't try to ban smoking in the common area. I think that you should. And I'm not suggesting you shouldn't try to pursue an amendment to ban smoking in units, but you just need to be aware, as with everything, when you do that, now you've created this new obligation on the part of the HOA to enforce the restriction. And so a couple more things about criteria for smoking restrictions. Let's say your documents are completely silent. You have nothing about smoking in your CC&Rs because they're older. You have no rule about smoking, nothing at all. Then a lot of times the nuisance provisions in an association's CC&Rs, they can be invoked. And because people do find smoke to be an odor nuisance, it does have health effects and problems like that we've talked about. A lot of times nuisance provisions can be cited if there's a smoke nuisance, but these generalized provisions, I've seen a lot of smokers and people that are accused of smoking fight back on the issue and say, I didn't do it, or smoking's not banned, or how do you know the level that I'm smoking at is a nuisance? And so I think looking at more specific smoking restrictions probably places the board and management in a more defensible position to kind of try and address the issue. And then, when we're looking at adopting these rules, or when we're talking about smoking issues, we need to think not just about cigarettes, because as Robin mentioned earlier, there's all kinds of ways that people can, smoke or ingest things. We've got hookahs and cigars and electronic cigarettes and vaping devices and all sorts of things. So when you're adopting a rule, when you're looking at a CC&R amendment, you want to think about the world of smoke devices and the world of things that can be smoked. And we will talk about marijuana in a little bit. So now over to you, Robin.
Thank you. Now, so let's talk about some smoking complaints. I'm sure, again, if you've ever, as a community manager, most of us have dealt with smoking complaints. So how does smoke travel? Well, everyone knows ventilation systems, pipes, electrical sockets. A lot of people are not, don't always think necessarily of electrical sockets, but it's a big thing. So if you've ever managed stacked units, a high rise, that is definitely one of the areas that's often overlooked. So important to keep that in mind. Walls, windows, floorboards, like Alex mentioned earlier, smoke is very much like water, right? It finds the path of least resistance, and that's where it's traveling. Varying air pressure and winds, if you're in a high rise where you've got negative pressure in the hallways, smoke can travel that way. And what's difficult is it's often hard to get evidence of secondhand smoke, as many of you know. A lot of times, the smoking is only periodic. It could be happening in different areas of someone's unit. And so sometimes it can be very difficult to try and assist someone when it's only happening intermittently.
And Robin, it could be someone that's not the owner that's smoking. It could be their guest or family member that visits, which makes it even more problematic, right? To try and trace it.
Absolutely, absolutely. And and again, and the funny thing about that also is not just the guest, but it really, you could be thinking it's your downstairs neighbor, and really it's coming from 4 floors down and 6 units over, right? So again, it just depends on how it's traveling and where it's coming from. Like you just never know.
Yep.
So now, are we required to enforce governing documents for someone who's hypersensitive? No, not generally. I think, as Alex mentioned, we're really trying to do, what would the average person think of this? Like what would be normal, because you're always going to have outliers, someone who's very not sensitive to it, and then you have someone who is very sensitive to it. So we're not generally required to enforce that for hypersensitivities, but it's really important for you to know, gone are the days of saying, oh, I'm sorry, that's a neighbor to neighbor dispute and I don't have to deal with that. You two will deal with that. Those days are over. So, you know, because there are known potential side effects of secondhand smoke, it's really important that the association adopt some kind of policy for dealing with secondhand smoke. And it's good. We do recommend that there is a formalized mechanism for complaints about smoke. And that way it helps establish the expectations of the person who's making the complaint, as well as the person who's being accused of the complaint.
Right, and this could be a policy that doesn't deal just with smoke, but other nuisance issues like noise, sound, vibration, odors, things like that, that kind of walks owners through. If there's a complaint about a nuisance, this is kind of the protocol we will follow, based in part on what's in the CCNRs and based in part on what's best practice or the board thinks is appropriate.
Yes, thank you, Alex.
Yep. All right, so some more on smoking complaints. So as with everything, just because you get a complaint that there's a smoke issue, that doesn't mean it's a smoke issue or that it's where the complainant thinks the smoke is coming from. So you need to have some sort of evidence, right? Owners are entitled to due process when you're going through the disciplinary hearing proceedings. There needs to be some sort of evidence or a pretty good indicator that a violation occurred, whether it's smoke or something else. And if you definitely want to pursue enforcement action, because sometimes boards feel like a problem's being complained about enough, or it's so persistent they want to go forward with IDR or ADR, maybe even a lawsuit, there needs to be some evidence of what's going on, and you need to figure out, is there a way to control this, stop this, what can we do? And so, you know, first of all, we need to make sure there's a problem. If someone complains about smoke, I think as with any violation complaint, there's a duty and obligation to investigate. And depending on your building and what's going on and what the complaint is, that investigation could be short or it could be more detailed. And, you know, when we've determined that there is a smoke issue, okay, there's smoke in the unit, but where is that smoke coming from? Because like Robin said, it could be a different floor, different part of the building. And what are we going to do to take care of the smoke issue? And so what I've had done with a number of buildings is that there's been a complaint, and what you can do is you can have an environmental technician come out where they actually will go through the unit and they will look for sources and areas where smoke can come through, like light sockets that don't have foam in them, where you don't have a door sweep under your door, where there's cracks in your wall or your ceiling, where someone replaced their lights in the living room or dining room of the unit and didn't put enough sealant or foam in it, because smoke can get in all kinds of weird ways. So you can actually have an environmental company come out and do an inspection, and they'll put together a report and note all of the different kind of issues or conditions in the unit or the home that could be leading to smoke emanating, assuming that that's the unit where the smoke's coming from. And so once you have that report, the board could meet with the owner and basically say, so this is what our expert's telling us, right? Because boards have the right to rely on third-party experts, part of the business judgment rule. And so we've got this report. There's no question there's smoking in your unit, assuming we've established that. And here's things that this expert's saying can be done or should be done in your unit to prevent smoke from emanating out into the common area, out into the unit next door, or wherever. And it could be that some of the issues are common area issues, something with between the walls or the ceiling floor assembly. So maybe there's something that the association may need to do to address an issue. But things within the unit like light switches and light fixtures and door sweeps and cracks and, you know, surface of walls, those are really things that owners for the most part should be taken care of. And so there is a way to try and get from a, you know, kind of scientific approach what we can do to deal with this. And it could be that there aren't really good fixes if it's an older building or the construction's not great. But I think this is a good starting point. And then, of course, the question gets to be, who's paying for the report? And so it could be that, depends on what your policies are and everything in your governing documents. It could be that you, the owner who's being, you know, accused of smoking or has a smoking issue is asked to pay for part or all of it. It could be that the board sees the HOA being drug into expensive mediation proceedings. And so we're going to have the HOA pay for part or all of the costs because we don't know exactly where the smoke is coming from. It could be that you ask the owner above or next door that's complaining to split the cost with the other owner and or the HOA. So it's really going to depend on how have you done things historically, what's in your governing documents, what makes sense. But I wouldn't take the position that automatically the smoker pays for the report or that the HOA pays for the report. And you may want to talk to your association's legal counsel about it or think about what you've done with similar issues in the past before the board just makes a decision on who they're going to demand pay for what.
I think that's a good point, Alex. I'm sorry to interject really quickly.
Good.
All the more reason why earlier we did say that it would be good for any association to have a formalized policy for doing that. I think one of the most important things that as a manager is handling things consistently, because when you handle things inconsistently, that's the kind of thing that gets you in trouble as a manager and as an association. So
yes, key with everything that boards do and managers do and associations do, consistency is key. Well, as long as you're doing it the right way, right? We want to do it.
Good point.
Have to be uniform, not be arbitrary, be reasonable, things like that. Good, very good point. So we've talked about what the smoking owner may have to do, but sometimes this person complaining of smoke may need to actually undertake actions as well, because it could be that there's no practical way for the smoking owner to completely eliminate smoke from their unit, or that if they take all reasonable efforts, there's still going to be some sort of trace amount, and we're dealing with a hypersensitive person or a situation where the person complaining is not happy with the fix, but we don't know for sure if there's going to even be a smoke issue after that. And so I've had situations before where a board, in conjunction with dealing with the smoking owner, has asked the complaining owner or resident, well, you need to do some things in your own unit to try and help make it smoke free. And that could be installing and using air purifiers, fans, things like that, to try and help the issue, especially if we're dealing with a hypersensitivity, with an issue where we can't really determine if there is a smoke nuisance or trace what's going on. I don't think we want to say neighbor to neighbor, back on you, fix it, because that's not the right answer. But the owner complaining may have an obligation to take steps. And most of the CCNRs, or hopefully most of the CCNRs we're all dealing with, they typically have a provision towards the end that says any owner can bring an action against another owner for a violation of the governing documents. And oftentimes it's hard for an association. We're an IT. We are, trying to deal with violations. We're not being personally affected by the smoke issue or the nuisance. And so sometimes there's a lot more power and import with the complaining owner getting their own attorney involved, or going to court, or asking for mediation with the other owner, whatever it is. And so I think there is a certain level of responsibility that needs to be on the complaining owner in some situations, not every situation, but some. And again, that's really a conversation a board should be having with its manager and legal counsel before they kind of take that approach. I think that when we're dealing with these smoking complaint issues, it's just, we can't ignore them. Like Robin said, and I want to kind of beat a dead horse here, is that there is really no such thing as a neighbor to neighbor complaint, in my opinion, with smoke or with a lot of nuisance issues. If there's a nuisance provision or there's a governing document provision that says you can't do this, you can't cause that, and someone's doing it, even if it's affecting only one owner, a lot of times there's a really strong argument to be made that the HOA has to step in and take care of the issue. All right, Robin.
All right, isn't this a great graphic? Mind if I smoke? Care if I die? I know that a lot of people feel that way. So going back again, talking about beating a dead horse, an association and board of directors actually can be held liable if they fail to address a complaint about secondhand smoke. If it's a nuisance, right, that violates the governing documents. So important. And again, whether or not we think it's necessarily a nuisance, if it is a nuisance to an owner, even if it just affects one owner, we as an association have a responsibility to, at the very least, investigate and try to mitigate. Okay. Now, a lot of people may not know this, but fair housing complaints can also be made by owners for failure to provide a smoke-free environment, right? Whether it's protecting children or anyone who's compromised, elderly. If we fail to address the issue of secondhand smoke, there could be some fair housing complaints made against us. And a lot of times insurance, unless you have, pollution, coverage, a lot of times insurance policies will not cover it. So really important for you to be aware of that.
Yeah, and that's really a good question to ask next time you're renewing your directors and officers insurance liability coverage or your commercial liability coverage. What are the exclusions under your policy? Because a lot of times pollution, which is what smoke is not covered, or defamation claims aren't covered. There's all sorts of exclusions. So I think when you're going through your renewal process, really talk to your insurance agent or broker to make sure you understand what are some of the common claims that could come that may not be covered. And this pollution issue is a big deal. And so we're gonna talk in a second about a case in Orange County that kind of illustrates the problems with an HOA not dealing properly with the smoking issue, but I kind of want to tell an anecdotal story before we do that. There was a high-rise that I was working with, and it's probably 8 years ago. The board there decided that they wanted to ban smoking in the units. They did a survey. I think out of the 110 units, there were 2 smokers in the entire building. So there was a lot of support behind banning smoking. They went through a CCNR amendment process where they prepared the ballot, they had a town hall, they sent everything out, and it overwhelmingly passed. There were only, I think, 1 or 2 no votes against the amendment. They got something like an 85 or 90% turnout. And what they did in the amendment, which I thought was pretty smart, was they recognized the fact, they knew that there was 1 owner in particular, or 2 owners who smoked, who were you know, older, had smoked a long time, and probably were going to be, you know, having an issue with smoking. They built in a 90-day kind of grace period or smoke out period, that once the amendment was recorded, there was this 2 or 3 month period where you could continue to smoke if you had been, and that by the end of that period, you had to find somewhere else to smoke so that you weren't in the building. But it was kind of trying to be somewhat reasonable with the implementation of this. And so one of the 2 smokers in the building moved out shortly after the amendment, or sold the unit shortly after the amendment was approved. And then the one remaining owner, I think she was 85 or 90 years old. She got an attorney involved, of course. So the HOA started getting, you know, complaints about, this is unreasonable, this is arbitrary, we demand IDR, we demand ADR. She bought the unit being able to smoke, therefore she should be able to smoke until the end of time. And of course, the attorney was not an HOA attorney, so there was some, you know, job on my part to educate him about the Davis-Sterling Act and CCNRs and things like covenants, things like that. So, you know, it got to a point where the owner's attorney realized that this was not going to be a winning case for them in light of Narstead and some other cases that, you know, uphold the fact that owners are subject to restrictions in governing documents. And so she went ahead and, you know, acquiesced to quit smoking. And then after that, every morning would get up and she would go across the street and smoke off property and make various hand gestures towards the building, and then she would come back. But she complied because she realized that it was going to be an expensive, you know, ordeal to go through, and she may not win. And so I just always think about that story. It was kind of funny with these smoking restrictions. So now we're going to talk about the case Chauncey versus Bella Palermo Homeowners Association in Orange County. This is a case from 2013. And what happened was in March of 2013 in Orange County, so we're talking Southern California, Orange County jury found that the HOA in this case, which is located in Trabuco Canyon, was negligent and breached its CCNRs for failing to resolve a secondhand smoke dispute between neighbors. And so one of the preeminent things in this case was the association's CCNRs had this nuisance provision stated here that said, no noxious or offensive trade or activity shall be permitted upon any part of the covered property, nor shall anything be done thereon which shall in any way interfere with the quiet enjoyment of each of the owners of his respective residence. So a pretty broad nuisance restriction, way broader than I typically would like to see, but I believe these were kind of original developer drafted documents, just kind of this blanket nuisance provision. So what happened was the background on this was 2 years prior to the jury award, the Chaunceys were a family, they lived in one of the units, and there were tenants that lived next door to them that were smoking and that they alleged were causing a problem. And they had sent multiple communications to the manager, to the board, to the tenants next door, to the owner next door. They showed up at board meetings, basically saying that these tenants were smoking on the sidewalk in front of their home, smoking in their units, smoking in the back, and that basically all around them smoke was going on that was coming into their units and their unit windows and doors. And of course, they had a young child with asthma, right, to throw on top of all of this. So as a result of the smoke nuisance, they decided, the Chaunceys, to move out of their unit and go elsewhere. And then they sued the association, saying basically that you breached your fiduciary duty because you didn't address this nuisance issue. So they sued the HOA, the board, the management company, and the tenants and owner of the unit next door. So probably everyone, you know, looks like was involved in this. And then there was a 5-week trial that ensued about this issue. And so the Chaunceys has sued for $120,000 in damages, and this had to do with emotional distress and physical distress, but also costs they incurred to move out of their unit and other various damages. And the jury found that the HOA and the management company had failed to ensure that the non-smoking family right, the Chaunceys, to the quiet enjoyment of their unit wasn't preserved, and the Chaunceys were awarded more than $15,000. And the jury award was $6,000 for economic damages, having to move, and $9,500 for emotional distress, plus attorney's fees. And the jury found that the HOA was 60% responsible for the emotional distress, and then allocated the other 40% amongst the management company and the owner and tenants of the unit next door. And so what this really demonstrates is that there is liability here. Courts are willing to look at CC&Rs and say, if there's a nuisance provision or a no smoking provision, the HOA is going to be expected to act in compliance with that. And the interesting thing about this case is how the management company got drug into the whole thing as well, not just the HOA or the board, which is what you would typically see. And so this is a local Orange County case. This really can't be cited for precedent necessarily anywhere, but I think it's really indicative of where a court would be willing to go with these sort of smoking issues. All right, Robin, on to you with your friend here.
Well, I don't always smoke weed, but when I do it every day, right? So now we're going to get on to the fun stuff, Prop 64, which is also known as the Adult Use of Marijuana Act, right? So we don't like smoking, but we like weed, apparently. So this was approved by the California voters on November 8th in 2016. I don't know, I wouldn't say it's necessarily close. I mean, obviously it was almost 60% of the California voters who said, yes, we do approve of Adult Use of Marijuana Act. It basically legalized recreational marijuana as long as you're 21 years old or older. And it also allowed for certain sales and cultivation taxes. So that became effective on November 9th, 2016. And then sale and taxation of adult use cannabis was legal as of January 1st, 2018. And again, this is California, so it just depends on your state again. So what does that mean? People under 21 or older can possess and transport and carry up to 1 ounce of of marijuana for recreational use, right? Whereas before it was not allowed at all, now it is allowed. But medical marijuana can still be used by people under 21. So now, this is really important. I think we've seen this all in the news. It's been all over the place. You cannot design cannabis products to appeal to children, right? Or something that could be easily confused with commercial candy. Now, this is kind of funny because if anyone, I'm dating myself here, but if you all remember as a child, smoking these little candy cigarettes, anyone used to do that? I know I did. So gone are those days. Those are no longer allowed, right? So nothing that's cannabis product can even look like, it's candy or anything. And they also have to be packaged in child-resistant containers, right? And more importantly, anyone who's under 21 cannot be in a cannabis shop. Now, can people smoke cannabis in a public space? The area is no, right? So unless it's allowed by a local ordinance, which, that would be kind of funny, right? Hi, cannabis-free, okay zone. You cannot do it. So, it can't be smoked in places where state law already prohibits smoking, right? So we talked about what the definition of smoking was earlier. Same thing. Marijuana is one of those items still cannot be smoked in places where smoking is banned. It's also outlawed within 1,000 feet of a school, daycare center, or youth center, which makes perfect sense. Again, if we're making it childproof or trying to make it childproof and trying to make it less appealing, we certainly don't want you anywhere near any of these items. And you can actually be fined if you are caught while it's still being under the influence of a narcotic if you're driving a motor vehicle of any kind.
Perfect. So Robin just talked about the fact that marijuana is legal if you're 21 or older to use in California. But what about medical marijuana? And so this raises kind of two issues for HOAs. One is that the marijuana law that Robin just talked about says you have to be 21 to use marijuana, but under fair housing laws, people that are under 21 can use medical marijuana. And then also, if you have an association that has banned smoking in units, smoking would correspond to marijuana, but not necessarily medical marijuana. And so the statistic here I thought was interesting. As of May of 2018, almost 1 million California residents use medical marijuana. It's a lot of people. And this was even after the law was passed that Robin just talked about, the Adult Use of Marijuana Act. The second point here is kind of an interesting point, is that here in California and certain other states, marijuana or medical marijuana is legal, but the federal government doesn't recognize that marijuana is legal. It's an illegal controlled substance. And so if you're in a state that doesn't have a marijuana law, or if you're on federal land, such as the District of Columbia, a military base, embassy, somewhere like that, federal park, national park, it's actually illegal. You can get in trouble for having or using marijuana there, even if it's, you know, in the surrounding state or city, you can use it. And so there's this tension about, do associations have to allow for, you know, marijuana in general or medical marijuana when the federal government doesn't recognize it? Well, we're focusing on state and local laws for the most part, and until the federal government busts into California and San Francisco and says you can't do it, we're still probably going to focus on state and local laws. And so this gets us to our third point here, which is that you're generally required as an HOA to grant reasonable accommodations for owners and residents with disabilities, physical and psychiatric, and that the California Compassionate Use Act and certain provisions of the California Health and Safety Code would require an HOA to allow an owner to use medical marijuana in their unit, even if smoking as a general proposition is banned within the HOA's building or development. That said, the right to use medical marijuana doesn't give someone a right to create an unreasonable smoke nuisance. And so if someone does have a prescription for medical marijuana and they're smoking in a non-smoking unit, they have to do it in a way that's not going to create an unreasonable burden on their neighbors or a nuisance. And so if they can't smoke in a manner that avoids the nuisance, the great thing is there's all kinds of ways to ingest marijuana. You can do it by vaporizers, capsules and sprays, edibles such as brownies and lozenges. You can get gummy bears. They have marijuana pan cooking oil essentially, right? You can cook your eggs in it. And so there's all sorts of ways to get the effects of cannabis or whatever part of the marijuana plant you're using medically. And so fair housing is always important. Avoid just saying no, get the HOA's attorney involved whenever there's a fair housing complaint. But we may be able to push back and say, wait a minute, sure, we're going to recognize your medical need, but you can't sit there smoking weed 24 hours a day, making the hallway and the units next to you full of smoke, right? Even though you have your medical marijuana card. All right, and then I think, Robin, we're ready for the conclusion.
All right, so again, just kind of recapping everything. If an association takes a position to not restrict or ban smoking, remember that both the board and the management company needs to be prepared to address the issue of secondhand smoke issues, right? And again, there's a lot of things that we're balancing here. So we need to be prepared to address these secondhand smoke issues. We need to make sure that there is some kind of policy in place so that we can maintain consistency. So all of those things need to be considered as you're doing this, as you're thinking about this, okay? Again, we should have an appropriate policy for dealing with this so that we can make sure that we're managing expectations of both the complaining party as well as the recipient of the complaint. And the reality is there's no magical solutions, right? We're not going to find a way to solve the problem for everyone. But if you're able to come up with a system and you use advanced planning, hopefully that will be more helpful in the long run for you to be able to address these issues when they come up.
Perfect. And now I think we are on to the question portion, which I think Nick or Kelvin or Charlotte, Sarah, somebody is going to help.
Sure, I'll take it from here. If you have questions, please post it on the chat. Our first question comes from Sherry Kostovsky. She has an individual that's been cited by the county, but continues to smoke inside her unit. The community has already placed outdoor designated smoking areas and has signage. What are other recourses against this owner?
Well, I mean, so we don't enforce, laws. We're not law enforcement for associations, and we're not health agencies, but we deal with nuisances, and if smoking is banned locally, then the HOA could ban it in units. I think that if the owner simply won't stop smoking, then we look at what are our dispute resolution options. So of course there's disciplinary hearings, there's internal dispute resolution, and then if it gets bad enough, alternative dispute resolution is a pre-litigation requirement. And then if it really doesn't stop, there could be a situation where the HOA actually has to look at getting some sort of restraining order or filing something in Superior Court to deal with the issue. I would strongly recommend the HOA's legal counsel be involved with this matter to make sure that you're kind of going about it the right way. But unfortunately, we can't stop people from doing things sometimes, so we have to get a court involved or a mediator or something.
Right, I agree, Alex. I think I've had to deal with this several times, and we have had to actually get an injunction to make it stop. Not that it, we still, obviously we can't go into someone's unit, gangbusters, steal their cigarettes and make them stop, but certainly it was one of the steps that was available to us.
Right.
Okay, next question is from Shelly Ortez. How about rules against smoking in exclusive use common area, like balconies and patios?
Yeah, absolutely. Exclusive use common area is still common area. So I think that most CC&Rs and governing documents I've seen allow the board to adopt rules regulating all the common area, including exclusive use. And I think it's common in my experience for balconies, patios, things like that, where smoking's not allowed because it's going to drift into the windows and patio doors of the adjoining units.
Yeah, I think in that case also, you know, going back to the whole local relations, local laws, you definitely want to make sure, like in San Francisco, obviously you cannot do that even if it's in a common area, but I know that there are some of our properties that are not in the city and county of San Francisco where if a deck is more than, you know, 20 feet long and you're more than 10 feet away from a door or a window, it is allowed. So again, it's definitely important to check the local laws on that.
Okay. Mariana Salfiti asks, we have an owner who is continuously complaining about cigarette smoke in her unit, intruding into her unit, but we cannot locate the source at all. This owner is clearly getting frustrated, but there's no way to help her. What do we do?
I think this gets to what I mentioned earlier about having an environmental technician or hygienist come in and try to source the issue. I had this happen at one of the buildings I work with in the South Beach area of San Francisco. There was an owner that was complaining of smoke. She didn't know where it was coming from. This company came in and they know what they're doing. They found that there was a pipe going from the kitchen sink down through the cavity to the unit below. There wasn't foam or sealant around it, and that's how the smoke was getting up. And so they put in some sealant and foam around this kind of penetration where the pipe was, and that took care of the issue. And so that may be something that the board needs to look at, or management in this case, to try and help with the issue. The question, of course, is going to be who's paying for it, like I said earlier, and the board's going to have to look at the facts and determine what it wants to do. But I think doing nothing's not the right response. I think it's the time to talk to an environmental person. And there's one company, it's called Healthy Building Science. They've worked with a lot of my buildings here in San Francisco, and they're one of the companies I know of that does this. So,
yeah.
Okay. Katie Moyer asks, she has a building where an owner is experiencing smoke intruding into the unit. They have a bird that, the pet bird, they're concerned about the bird's lungs, or the owner's very concerned about this bird's sensitive lungs.
yeah.
All the other owners are saying they don't smoke. What responsibilities or liabilities does the HOA have to protect this bird?
This is the new one. Yeah. So, well, I don't know that the HOA does have a responsibility. I don't think that birds are subject to fair housing laws. I think animals are actually considered personal property, right, under the law.
Yes.
So that's a tough one. I don't know that there's much you have to do, but I think because of the complaint, there needs to be some sort of record trail that indicates we got the complaint, we analyzed the complaint, we responded to the complaint, and we said sorry, or whatever the answer is. And so again, it's getting the association's attorney involved to help the board frame the issue or write the letter. But I don't think we have an obligation to Tweety Bird to not have her exposed to smoke.
And I think that's also one of the things that we talked about earlier, is that it's not necessarily that we're always going to solve the problem for everyone, right? But we have to do the investigation at least, and try to take steps to mitigate problems. But yeah, I agree with Alex on the Tweety Bird.
Right, now, if there's evidence of smoke in the unit or there were residents that were affected, it's one thing. But if it's simply just the bird, I don't know if there's anything that you can really, like, I had this happen once at a building where there were children outside playing with a ball, and the owner complained that the ball noise was affecting the bird, but it wasn't affecting them or anyone else. And so it's a weird issue.
Kimberly Nakata asks, please qualify hypersensitive. I have an owner that she believes would be hypersensitive, but what would we use to evidence this or to back up our opinion that they're unusually sensitive?
So that would be someone who an average person wouldn't find the issue to be unreasonably disturbing or annoying or offensive. And so depending on what the issue is, smoke is one thing. I guess if they're saying there's smoke in my unit and they smell the smoke right now, and you have the manager and the board member in there and they're smelling and they can't smell the smoke, then either there is no smoke smell or it's so trace that they're, you know, having some sort of hypersensitive situation to it, I guess. I see this with noise issues all the time, where you hear the the footfall and the doors closing above, where an owner below is complaining that it's a noise nuisance, but then you have the manager and the board or whoever go in, or the acoustical testing, and it's just normal noise that you're going to have. I don't think there's normal smoke that you're going to have, but if you can't experience the smoke, or you do and you think that it's not what an average person would find offensive, then that's where we get into the discussion of, is the person hypersensitive?
Right, and it's important to get that independent verification, right? So someone beyond just that owner, because it really does go back to what would a regular person feel about it? How does a regular person?
Right, which gets us to nuisance complaints in general. Is that my opinion typically is that one owner complaining is often not enough. You need multiple owners complaining. You need a police report. You need a sound or video recording. You need the manager or the board member to experience it. You need something else to put the board in a defensible position to try and pursue discipline or enforcement action. Otherwise, it's he said, she said. It's not the owner's lying, but if there's no evidence, how do we know they're not lying, or that it's not that it is an issue, right? So.
Okay, we'll make this the last one. Dave Himmelblau is in Santa Clara County, and he's experiencing more smoking complaints because of the shelter in place. And he feels like we're in between a rock and a hard place. So if he allows smoking outdoors, then the smoke might drift into people's homes through open windows. If he allows smoking indoors, that smoke could move through attic spaces and through walls, and could still transmit. And if they ban smoking entirely, you've got people sheltered in place who need to let off some steam, or that are addicted to nicotine and need to smoke. What do we do?
Well, I think we have to look at what's in the documents currently. If there's currently a ban on smoking in the common area, don't let people smoke in the common area, right? That should stay. If there is a ban on smoking in units, don't let people smoking in units. Don't let them smoke in units. I think that if there is no ban, or it's allowed some places but not allowed others, you continue as you continue unless you adopt a new rule or you amend the governing documents. But we keep in mind the nuisance issue. And so if it really is becoming a problem, I think you send a notice out to all the owners saying that we know there's people that smoke in the building. We're all home nonstop now. We're confined together. People should be taking extra care to make sure they're not creating a nuisance. Here's things you can do. Open your window when you smoke, turn on the fan in your kitchen and bathroom, whatever it might be to help with the issue. What do you think, Robin?
Yeah, so for that, I again, whatever, as far as common area, definitely cannot do anything in the common area, but I think it's one of the situations where you do send out just a friendly reminder to everyone to be mindful. We're all sheltering in place, right? So please try to be mindful of what's happening out there, and again, enforce what you can and ask for people's cooperation where you can't.
Right, and if you live in a city or county that already bans smoking, you can't say now you can smoke in your unit, right? And so if that's already a law, that's what it is. And if someone is in a position where they can't leave their house, the property, or don't want to leave the property because of shelter in place to smoke, they're going to have to figure out something. But the HOA can't say it's okay to smoke in your unit, because they're going to be exposing themselves to a big legal liability issue potentially. So.
All right. Well, I want to thank our speakers today. Thank you guys so much. You guys are great. Everybody stick around. We are going to do the raffle drawing through Zoom. But I want to take one more chance to thank our program sponsors. They are AC Enterprises, Alliance Association Bank, Cagwin and Doward, Chex Law, Empire Works Reconstruction and Painting, Fenton Grant Law Firm, Heritage Bank of Commerce, Hughes Gill Cochran Tinetti, Levy Erlinger and Company, the Miller Law Firm, Newman Certified Public Accountant, Sarman Construction, Sachs Insurance Agency, Signature Painting and Construction, and Socher Insurance Agency. At this time, I'd ask our sponsors to go ahead and turn their video and audio on so that we can conduct the raffle drawings. Rachel or Kelvin, how do we order this?
Hi, I have a Wheel of Fortune up, so I will share that when we are ready. Lots of names on that wheel.
Wheel of Fortune.
Right, pretty much.
So we have two. We have Charlotte Allen and Mimi Cortez, who'd like to give away a raffle prize.
Let's, oh, Nick, you're muted.
Okay, guys, take it away.
Charlotte, you want to go first?
Kelvin, sorry, say that again, Kelvin.
Did you want to go first?
Oh, sure. So Social Insurance. Hello, I'm Charlotte Allen with Social Insurance. I miss you all. It's hard not seeing all your faces, but I see your lovely names. We are giving away a $100 Amazon e-gift card. So I will get your email address and make sure that you get that in the next few minutes.
Okay.
Rachel's gonna pick the winner.
Share the wheel. Oh no, Rachel's not picking anything. Look at that.
How fun!
You have your video on, Rachel?
No, but I'm sharing my screen. Can you see it?
No.
I see it. The
April
winner.
Lochner.
Yay! April, I will send you the $100 Amazon card. Thank you.
Thank you.
Okay, and now stop share for Mimi. Uh-oh.
I think you're still muted, Mimi.
Mimi, are you on? Unmute in the lower left-hand corner.
She's not muted. It's the. Take the headphones out, Mimi.
I did. Can you hear
There
me?
you go.
Okay, perfect. Great. My name is Mimi with Saks Insurance, and I have two $50 gift cards. So let's spin the wheel.
Woohoo! All right, here we go. Can we see the wheel?
Yeah.
Okay, we'll spin it twice.
Oh, Laura Rabasa, congrats.
Woo. Okay, one more time.
Ronnie Gutierrez, perfect. I will be sending those gift cards to your office, or if you want me to mail them to your personal homes, I will send you a private message. Thank you, guys.
Yay. Thank you, everybody. We'll see you at the next event soon. Don't forget, we have the CID law courses coming up. You're also going to receive a survey in your email, as well as the contact information and list of sponsors who sponsored the event today.
Thanks, everybody.
Thank you.
Stay safe.
Everybody.
Bye, guys.
Stay healthy.
Good job, guys. Thank you.